Demetrius Burks. Stand up.
All right, this is case number 254610FY, the people of the state of Michigan versus Demetrius Alexander Burks. We are here for an arraignment. Mr. Burks, you met with somebody from Community Corrections today and gave them a phone number and an email address. Is that information accurate?
That information is accurate.
Did you have the opportunity to meet with somebody from the public defender's office today?
I did.
I have a complaint that alleges that on or about October 30th, 2025, in the city of Cadillac of Wexford County, it is alleged in count number 1 that you committed the offense of police officer assaulting, resisting, or obstructing. That is a felony punishable by up to 2 years in prison and or a fine of $2,000, and consecutive sentencing may be imposed if it happened in a place of confinement. Additionally, the prosecution has elected to charge you as a habitual fourth offender, which means that you have at least 3 prior either completed or attempted felonies in your past. That makes that 2-year felony a 15-year felony. In count number 2, it is alleged you committed the offense of assault or assault and battery upon a Jordan Dickinson. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $500. And again, consecutive sentencing may apply if it happened in a place of confinement. In count number 3, it is alleged that you were disorderly drunk. That is a misdemeanor punishable by up to 90 days in jail and or a $500 fine. Do you understand those charges and the potential penalties?
Yes, I do.
All right. On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning you consent to, and the right to stop answering questions at any time. You also have the right to be represented by an attorney at all phases throughout this process. And if you could not afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Request a court appointment.
All right. What is your current source of income?
I'm just a college student.
All right. The court will make a referral to the defender's office for the appointment of an attorney. Will enter a not guilty plea on your behalf. We'll set this matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. And at that hearing, the prosecution will be required to prove 2 things. 1, probable cause that the crime had occurred, and 2, probable cause that you were the person who had committed the offense. If the prosecution is not able to do that, the case would be dismissed. But if they are able to do that, you'd be bound over to stand trial in circuit court. Prior to the preliminary examination, there'll be a probable cause conference. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Historically, counsel, I show an 05 an aggravated assault, 06 a minor with any BAC, 06 driving a license suspended and operating while visibly impaired, 07 2 convictions for delivery and manufacture of a narcotic less than 50 grams, 16 unarmed robbery, actually 3 convictions for that, and 16, and 24 an assault and battery, 24 resist and obstruct and disturbing the peace, and 25 a disturbing the peace, and then out of state in 13 there was a receiving stolen property. The praxis scores him at a risk level 6, a high risk. It does indicate that he's got charges pending out of Isabella County and does not appear for tests, and when he does appear, he tests positive. Any comment regarding bond, Mr. Hartel?
Yes, Your Honor. I would ask the court to factor in that he did mention being unemployed. Even a low monetary bond would be essentially unreachable for him. I know the court did mention some concerns. However, he did mention that he has ties to the local community, and even Isabella County is not super far away. I know it's not northern Michigan at that point, central Michigan, but he does have ties to the state of Michigan.
Did he give you an address?
Oh, did he?
He didn't give one to community corrections in the complaint.
He told me that he was at the, I apologize, that he was at the homeless shelter, but he wasn't sure if he could go back.
Okay.
He wants to try to stay in the community. Yeah.
All right.
Sometimes I forget everyone can see what's on my sheet here. But he does have every intent to come to court proceedings. I don't doubt he would obey bond conditions. I realize that there's concern that he may have not always obeyed the conditions in his past files, but I would ask the court to consider giving the possibility for either a PR bond or as close to a PR bond as possible with whatever bond conditions the court feels appropriate. But I would ask if there is testing. I realize that's part of the allegations, but to keep that as minimal as possible due to the fact that it does cost money to test, obviously.
Thank you. Ms. Lawrence, on behalf of the people.
Thank you. I think it's pretty clear looking at the defendant's history that this is a pattern of behavior for him. I do think there is a serious public safety concern. Based off my reading of the report, the victim in this case is a stranger that he walked past on the street. The victim stated he seemed like he was under the influence of drugs or alcohol. He wasn't sure, and he was staring at his daughters and his partner, and he told him to move along, in which the defendant assaulted him. I think that is pretty concerning to public safety that he is out here assaulting strangers on the street, essentially. Given that, I am going to ask for a monetary bond of $10,000. Additionally, I would ask for random alcohol testing as well as drug testing in this case. I will leave the no contact order up to the court. I'm not sure if one is necessary. As I said, the victim, I believe, is a stranger to the defendant. So I will leave that to the discretion of the court. Thank you.
What is the basis for the R&O?
When officers found the defendant at a gas station, he was very uncooperative, swearing at the officers, and then when the officers told him he was under arrest, he was pushing, pulling, resisting, was kicking the inside of the police car door when they tried to put him in there as well.
Did they do any type of PBT?
They did not.
Given the defendant's past with robbery convictions, assault convictions, and what's been alleged today regarding the assault, I do find that he is a threat to the community. As a condition of his bond, sir, you are to appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm also going to order that you not consume any alcohol, and you'll be subject to random testing. No illegal controlled substances, including recreational marijuana, and you'll be subject to testing for that. No contact with Jordan Dickinson. Not to act in any threatening, intimidating, or harassing behavior. Mr. Burks, I'm not seeing a case pending for you in Isabella. Is there a case pending down there?
There it is.
Yes. Okay. All
Yes.
right.
Unless it was dismissed, it's pending. I don't know. I probably should call my lawyer and find out though.
Do you know
That's
what
might
the
not
char-
be.
Without telling me anything about the case, what's the charge?
Possession of a narcotic.
All right. Until I know more, bond will be set at $10,000 cash surety. Next arraignment. Morning, everybody. Welcome to the 84th District Court. First case this morning is the people of the city of Cadillac versus Juan Daniel De La Rosa, case number 2543270T. Mr. De La Rosa appears by Zoom. Are you able to see and hear the court?
Yes, Judge, I am. Good morning.
All right. Sir, what is a good mailing address for you?
2679 58th Street, Fenville, Michigan.
And a telephone number?
512-574-0983.
Do you have an email address?
Yes, sir. jdelarosa19@gmail.com.
Did you have the opportunity to meet with somebody from the defender's office today?
No, sir.
All right. I have a complaint that alleges that on or about October 6, 2025, in the city of Cadillac, Wexford County, it is alleged that you committed the offense of operating a motor vehicle without security or insurance. That is a misdemeanor punishable by up to 1 year in jail and or a fine of not less than $200 nor more than $500. Do you understand those charges and the potential penalties?
Yes, sir.
Did you receive from the court an advice of rights form that talked about your rights to an attorney and your rights to a trial?
Yes, sir.
Did you read that form?
No, sir.
All right. I'm going to go through your rights with you.
Yes, sir. Thank you.
If you require accommodations to use the court because of disabilities, or if you require a foreign language interpreter to help you more fully participate in court proceedings, please contact the court immediately to make arrangements. You've been brought to court on a misdemeanor charge, and you have the following basic rights: to plead guilty or not guilty, or to stand mute. If you stand mute, a plea of not guilty will be entered. You may plead no contest with the permission of the court. You also have a right to have a trial by jury and to have the assistance of an attorney. You have the right to an attorney appointed at public expense if you are indigent, which means without money to hire an attorney, and if the offense charged requires a minimum jail sentence or the court determines that it might sentence you to jail. The appointing authority will decide if you are indigent and appoint counsel if you are eligible. You may have to repay a portion of the expense of an appointed attorney. You may contest your ability to pay the ordered fees if the court attempts to collect any cost for an attorney, and the court must determine your ability to pay at that time. If you have a trial, you have the following rights: to call witnesses to speak for you at trial. You may get an order signed by the court to require witnesses to come to court. To see, hear, and question all witnesses against you at trial. To be a witness for yourself or remain silent. If you choose not to be a witness on your own behalf, the prosecuting official may not comment on your refusal to testify. You have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. If you plead guilty or no contest and your plea is accepted, you will not have a trial of any kind, and you'll be giving up the rights that we just went through. You have the right to be released on bond, and we'll get to that in a moment. If you are now on probation or parole and you enter a plea of guilty or no contest, or a finding of guilt is made by the judge or jury, it may result in a violation of your probation or parole. You can be sentenced to jail, fines, plus costs. The court will tell you on the record the name of the offense, the mandatory minimum jail sentence, if any, and the maximum possible penalty for the offense, including jail, fines, or both. Fines, costs, and other financial obligations imposed by the court must be paid at the time of the assessment, except when the court allows otherwise for good cause shown. If you are not able to pay due to financial hardship, contact the court immediately to request a payment alternative. An appeal to the circuit court may be taken within 21 days from the date of sentence, or is permitted pursuant to court rule. If the sentence includes incarceration, and if you wish to file an appeal but are financially unable,
What time is it?
financially unable to retain a lawyer, the court will appoint a lawyer to represent you on appeal if the request for a lawyer is made within 14 days from sentencing. Federal law and or state law may prohibit you from possessing or purchasing ammunition or a firearm, including a rifle, pistol, or revolver. If you are convicted of a misdemeanor crime of violence and you are a current or former spouse, parent, or guardian of the victim, you share a child in common with the victim, you are cohabitating with the victim as a spouse, parent, or guardian, or you are or were involved with the victim in another similar relationship. Do you understand those rights?
Yes, sir.
You do have the right to be represented by an attorney at all phases throughout this process, and if you cannot afford one would be appointed to represent Ms. Lawrence.
I apologize, Your Honor. This one is actually going to be a dismissal.
Oh, all right. Well, I got my reading in for the day. Mr. De La Rosa, Ms. Lawrence, on behalf of the people, has just notified the court that she's going to dismiss this case. I assume that's with prejudice, Ms. Lawrence?
Yes.
Judge,
Yes.
I have a question.
Yes.
Will this be on my record if it's dismissed?
So it will be on your record, but it's going to show as a dismissal. So it'll show that you were charged, and then it will show it was dismissed.
So I'm trying to get an expungement on a different case. Will that disturb that case if it's dismissed?
I can't give you legal advice, but I can't give you legal advice.
Okay. All right.
So when I receive the dismissal, I will sign that. It's being dismissed with prejudice, which means it can't be brought back. But even though you were charged with a crime and it's being dismissed, you're still required to get your fingerprints taken. So I have signed a fingerprint order. You'll be receiving a copy of that order. You'll need to contact the Wexford County Sheriff's Department and make arrangements to get those prints taken. If you don't do that, your criminal history won't be complete. So it'll just show that this charge is just hanging out there and was never resolved. So you need to get those fingerprints taken, all right?
Yes, sir.
Okay, thank you for being here this morning.
Well, thank you, Mr. Judge Wiggins. Appreciate it.
Thank you. Thank you.
Can I leave?
You are free to go. Yep.
Alrighty. Thank you, sir.
Court next calls the people of the state of Michigan versus Isabella Marie Garcia, case number 254390 ST. Ms. Garcia, is that you on Zoom?
Yeah.
Are you able to, obviously you can hear me. Are you able to see me?
Yeah.
We are here for an arraignment. I have a mailing address on Cedar Hedge Trail in Interlochen. Is that accurate?
Yes, sir.
Do you have a telephone number?
Yes, sir.
What is that?
231-463-8334.
Do you have an email address?
Yeah. Izzy, IZZY, Marie, MARIE, 2470@gmail.com.
Did you have the opportunity to meet with somebody from the defender's office today?
No.
I have a complaint that alleges that on or about October 13th, 2025 in Liberty Township of Wexford County, it is alleged that you committed the offense of operating a motor vehicle with no license or multiple licenses. That is a misdemeanor punishable by up to 90 days in jail and or a fine of $100. Do you understand those charges and the potential penalties?
Yes, sir.
Did you receive from the court an advice of rights form? It talked about your rights to an attorney and your rights to a trial.
Yes, sir.
Did you read that form?
Yes, sir.
Did you understand those rights?
Yes, sir.
You do have the right to be represented by an attorney at all phases throughout this process. And if you could not afford one, one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Last one.
What is your current source of income?
I make
What do you do?
I'm a caregiver.
All right. The court will make a referral to the public defender's office for the appointment of an attorney. Will enter a not guilty plea on your behalf and will set the matter for a pretrial. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Ms. Lawrence, Mr. Harrison, any objection to a PR bond in this case?
No, Your Honor.
No. Ms. Garcia, I am going to allow you to remain out of jail on a personal recognizance bond, which is your promise to come back to court with these conditions: that you appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes.
Okay.
Do you have any questions for me?
No, sir.
All right. You'll be receiving your next court date. If you don't get that in the next couple of days, make sure you contact the court. And then within a couple of days, you'll probably be hearing from the public defender's office as well.
All right. Thank you.
All right. Thank you. You are free to go.